While we're waiting, I did have one comment about that judicial notice. There was a good, really great question about that. Um, Judicial notice is really a place where the judge will just determine a fact without having presented any evidence. It's something that's common knowledge. It's something that the judge usually doesn't want to waste the time going over a bunch of evidence to prove that fact. So he'll just take judicial notice that it's a fact. Unless the other party objects, then you don't have to present any evidence to support it. I was in a case once where we had a bunch of aerial photos to present. And some of them were ortho photos and scalable, some of them were rectifieds, and some of them were just obliques and non-scalable. And so we started to go in this line of questioning about, well, what's an oblique photo? What's an ortho photo? What's an oblique, and when can you use them and stuff? And we got about 5 minutes into this line of questioning, and the judge sits up and says, do I need to know any of this? And we said, well, we're really just laying the foundation here that, some of these photographs are scalable and others are not. And so you'll see in some of these exhibits where the photos seem to be in different, shifted to different positions and warped out of place. And he says, oh, okay, yeah, fine. I'll take judicial notice of that. Roll on. And so that just ended the entire line of questioning and saved a whole bunch of time in court. And
that's cool. That's too funny. do I really need to know this? That is awesome. I love that. Actually, so I think I don't want that information to get lost. So I think we'll just kind of trim the session just before that. So I think we can probably, without doing my little disclaimer, because anybody's reading, kind of watched it before that. So we'll use that as our starting point there, but that's cool. So Trent Williams was working on kind of, since we weren't getting a lot of roundtable discussion, he was going to kind of do a PowerPoint side of presentation, but I don't know how you want to kind of lead off this week, Trent. And I would imagine since you're in a parking lot, you probably want to leave your video off to save bandwidth for chatting. So, but
yeah, I've actually got, I've got my camera on here. I've got it. I had a whole setup. I even tested it beforehand.
Oh, there you go. Okay.
It's sitting right there, but it's the computer and my phone and everything's just, it's not working. So I'm just going to keep my camera off so I can flip back and forth.
Yeah, that'd be perfect.
But I think with this one in particular, each of these keeps building upon the next. Right. And this chapter 3, I went through a few times because there is, if the other chapters had a lot of information, this chapter had even more information to go through. We could almost split this into 18 different videos for each of the principles that are contained in here. It was really good.
Yeah.
I did just want to kind of take a second. I was thinking about after last week. I know I was a little rushed again last week. I had a city council meeting to get to, and I felt like we didn't have quite the participation that we have had on the first one, and part of that's due to great people like John that are willing to speak up and have a lot to bring. But I just want to take just a couple more seconds and just kind of reiterate the purpose of this. And again, my background is I am not a subject matter expert. I am learning this as much as probably anyone else in this call. So my goal is hopefully not to teach it, right? I like teaching. I'll toot my own horn. I'm actually a pretty good teacher in a classroom setting. But Zoom's a tough one for me, but I don't want to be a teacher. I don't want to sit and just talk and read out of the book. I really do hope that even if you don't know the material, or even if you haven't actually read the chapter, my plea is to everyone on the call to please jump in and be part of the discussion, because that's the whole point of a round table and the book club format. So I'm just going to throw that out there. Help me, help you, so we can do this together. So with that, let's just jump right into this. Words as evidence. And I think the best way to start, and again, I said I didn't want to read off everything, but I think, and we'll see how the discussion goes today, but what I want to do is just quickly read off. There's 18 principles that this chapter covers. And let's just go through those 18. We'll read them all right now real fast and just kind of get a basis for what we're talking about. And for the most part, let's just take these one by one and have some discussion. A couple of the principles have only a chapter in the book. A couple of the principles have a couple of pages. But let's just start discussing what we found. I had a deed to pull up, and I'll probably pull up my camera, see if I can't share it with you guys that fit perfectly into this, and maybe look at some real world examples as we go through it. But I'll just read through these, and then if anyone has anything to say, please chime in as we start going through it. But we'll get through these 18 bullet points, and then we'll just jump back into point number 1 with our discussion. Principle number 1, a written conveyance is indispensable evidence in the claim and proof of ownership. Principle 2, all words in any written document should be interpreted as having the meaning at the time of the document was created and not at the time today's surveyor attempts to retrace it. Descriptions do not identify themselves, and all that is required of a deed is that it furnishes evidence or a key of a means of identification. If the description in a deed is sufficient when the deed is made, no subsequent change in conditions or loss of evidence can render it insufficient. Principle 4, when the terms of an instrument, deed, or will have been reduced to writing, they are to be considered as containing all those terms, and there can be between the parties or their representatives or successors in interest no evidence of the terms of the instrument older than the contents of the writing, with several exceptions. Each deed should be construed as a whole. All parts are read in the light of other parts. Nothing stands alone and nothing is rejected unless it is impossible to give that part a meaning. Principle 6, writings or plats referred to in a conveyance for the purpose of identifying land are to be regarded as part of the conveyance in itself as much as if incorporated into it. Principle 7, where the law requires field notes as part of a survey and the notes are stored in a public place, reference to the survey includes reference to all the field notes of that survey. Principle 8, extrinsic evidence may be sought to explain, 1, the meaning of words existing within a written conveyance, and 2, the conditions existing as of the date of the deed. Principle 9, evidence of practical location, written or parole, when appropriate, may be received to clarify ambiguity of writings. Principle 10, ambiguous deeds or descriptions that cannot be cured by extrinsic evidence may be considered as void or voidable by the courts. Principle 11, an ancient survey record or accepted as a public document made by a competent authority and produced from proper custody is generally admissible as evidence to prove the location of a boundary line. The intentions, or principle 12, the intentions of the party to a conveyance as expressed by the evidence of the writings are the paramount considerations of the court in interpreting the meaning of a deed, and that intent is gathered exclusively from the written word of the deed, except where the written words have extrinsic ambiguities or where explanations of conditions existing as of the date of the deed are necessary. Principle 13, depending on the evidence discovered, a conveyance is classified with respect to the adjoiner as being senior in rights, as being equal or simultaneous in rights, or as being junior in rights. An intent gathered from the written evidence cannot alter senior rights. The words, or principle 14, the words of a written conveyance are conclusive evidence as between the buyer and the seller, but they are not conclusive evidence against a third party who has senior rights or a person with occupancy rights. Each deed is construed as a whole. Parts are real in the light of other parts. Nothing stands alone and nothing is rejected if it is possible to give every part of the deed meaning. Testimony of interested landowners is one form of evidence that must be considered by the surveyor as a part of the totality of evidence. Not to do so may be a serious flaw in the collection of any evidence. Principle 17, words that are translated from one language to another have meaning inferred in the original language and not in the second language. And finally, principle 18, in ancient documents, the words that have meaning that they had at the time they were written and not the meaning in today's definition. So those are the principles we're going to be covering tonight. And they kind of build off one another there. I think they also get fit into three kind of groups, if you will. The first few are really just about the deed, the words in the deed. And then the next one, starting probably around principle 7 and even principle 6, start talking about things outside the deed. References to a plat or a subdivision or an adjacent survey or testimony, parole evidence, so those are the next ones. What can we do outside of the deed? And those last are a lot more about rights, the rights of the deeds, rights of the landowners and adjacents. And so that we'll kind of build off of each of those. So jumping on to principle 1 then. Principle 1, a written conveyance is indispensable evidence in the claim and proof of ownership. The stuff that pops out to me right away, the stuff that we should all know at a very basic level is, in the United States, land must be conveyed in writing to be valid. Anytime we do research as surveyors, that is what we are looking for. The deed, the vesting document, the written conveyance, what is actually being conveyed. That is what we are judging and reviewing when we begin or perform a survey. And I found with inexperienced surveyors, they may pull up a GIS map, right? And there's a tax ID, tax description, written under that, and they pull out that tax description and they start punching it in, and I've seen them do surveys off of that description. All right, that's probably the first red flag right there. You need to go to the face of the document. Again, some of the stuff we'll talk about here in a second, the intent, the actual written words that are in there get lost in, for an example, a tax description. It's truncated to be able to fit on a screen real quickly and just convey the shape, size for tax purposes. But that is not what we base our surveys off of. So writings as indispensable evidence, the vesting document, the deed that actually conveyed that, and then historical deeds. Maybe the one we're looking at isn't sufficient, so you have to go back in time and see how those properties were conveyed to get to yours, if they've truncated that in other ways. It gives a great example here. And let's see, 1, 2, 3, 4 paragraphs down in this principle 1. Hunt versus Feast. 3 landowners were involved in a lawsuit over the riparian boundaries within a semicircular cove. One surveyor was hired by Hunt and Pounds, while another surveyor was retained by Feast. Since riparian boundaries are simple extensions of upland boundaries, the first surveyor conducted a full boundary survey of all properties within the cove and then retraced the riparian boundaries after locating all of the upland boundaries. The other surveyor was impeached on cross-examination by Hunt's attorney and admonished by the presiding judge because the surveyor, 1, failed to follow the record conveyances, right, the vesting document of the properties, and 2, failed to conduct an upland survey of the properties before locating the riparian boundaries. And that goes into some of the stuff we've talked about before. They didn't do a full survey, right? They didn't look at all the evidence. And 3, place an adjacent property's legal description on the face of the Feast's survey map. Hunts and Pounds ultimately prevailed. This case demonstrates the need for surveyors to follow the words words as evidence of any property boundary and to always verify the correct information is contained in the survey plat. Otherwise, the surveyor opens himself or herself up to impeachment by fellow surveyors, attorneys, and the court. And I think in proper fashion here, there's some big words in here, right? We're talking about words of evidence, and I've got 3 young kids, and we'll use big words at home, and they'll look at us with that blank stare, like, but they won't ever say anything, right? They'll just ignore the word they don't understand. And so there's some big words in here. I hope we understand it. Maybe we don't. So I just want to take a special emphasis as we talk about this chapter to maybe stop and look at some of these bigger words here. So impeached, and the surveyor was impeached by the presiding judge, and so that's the judge declaring that they've done it wrong, right? That there was missteps in his survey. Riparian boundaries being the water boundaries, right? Riparian having to do with water and the boundaries of which can come in a lot of different ways. Any comments or thoughts about principle 1?
Just real quick on your repair and boundaries. Chris Klein's going to be on Mentoring Mondays, July 18th, I think it is. So that'll be a good one to kind of, for some people to kind of, who may watch this, circle back and want to watch that particular one as well. So I think that'll be week 81. I think it will be. So just a heads up on repair and boundaries.
Okay, good. Yeah, that's one that, it's one I don't touch because it's one I don't understand, right? I know just enough to know what it is. And I avoid it at all costs because that does take some special training and some understanding.
Yeah. Both Jerry and John are unmuted, so go for it, boys.
Go for it, guys.
Going back to your comment about the young surveyors using the GIS because it's a convenient way to get information real quickly. The first words out of a surveyor's mouth with respect to a client that's when you're hired to do a survey is, can I have a copy? Can I have your deed? Can I see your description? Because they are the ones that are in possession of the writings. Most of them don't realize that. They think it's out the Register of Deeds office. And that's not, that's a copy. But that should be the very first thing that you ask for, is because of this principle right here. It's the written intentions of the party that exist because of statute of frauds. And that's your starting off point. And like you say, you have to trace that back sometimes because the description may have been rewritten at some point, particularly if it has contemporary units in it and it's an older looking parcel. So you have to go trace it back far enough to, like I say, when were the boundaries created and what are their relationships to the surrounding parcels?
Good point. I was going to add that when you talk about writings as indispensable evidence, the writings aren't always just in deeds. You have to be careful of the writings as in what documents actually created the lines or what documents actually transferred the rights. And I oftentimes end up in positions where the property right was created by, say, a statute, a state statute or a federal statute, or even a local ordinance affects property rights, setbacks, things like that. So making sure that we're not just looking at deeds, but paying attention also to those rights and restrictions that are imposed on property. And oftentimes even CC&Rs, covenants, conditions, and restrictions that are recorded against properties, against subdivisions, HOA documents. A lot of times there's easements and rights that are granted or reserved in those documents. And so we've got to try and keep the broad perspective, I think, on what we think of as documents that, we just want to run to the deeds and expect everything to be found in the deeds and in the title record in the recorder's office. It's not necessarily the case. So just keep that in mind.
Yeah, that's good stuff. I had something that, and I kind of going back to Jerry's point too, would be, going back to kind of contract law, right? I mean, our contract says our survey will be based on a current title report provided by the client, right? I mean, that's kind of number one you want on a survey contract, and back to Jerry's point, having that deed of ownership as well. So go for it, Zambra. Zimbara. Oh, there you
I
go.
think it seems like when you do a research, let's say, for example, a 30-year-old subdivision, as a private surveyor, I think it's answered in there, but please clarify to me, which one is paramount? Is it the subdivision, the recorded subdivision map, or the deed? Or every time you have a work that is related to a subdivision, you have to go over the subdivision map as well as the deed? And
Usually when you're in a platted subdivision, the description really is just a reference to that subdivision plat. It'll be like lot 4 of Sweetwater Edition. So that automatically brings in the plat, and all the information on the plat is part of the description. So when you see a description like that, and it refers to that plat, you have to get that plat and the plat information also.
okay, so okay. Do you also, as a surveyor, do you convey your field notes along with the project that you have created? Is that something that is healthy to do on your work?
Did you say provide our field notes
Yes.
to the client?
Yes.
Yeah, no, not typically.
No, to the, like, for example, if you do a subdivision map, do you provide the field notes as part of the plans that you create?
No, not typically. Just the subdivision map as it's recorded would be basically the final official document. I mean, if there's questions that arise, right, when other surveyors come back and rebuild that information, they may come to you and ask for some of that backup documentation to help them. But usually the final recorded map is the final document at that point.
Yeah, I would add, again, we've talked about this, the unique way that Utah does their surveys, where you file a survey with the recorder's office. Generally accepted practice and really required practice in most counties in Utah, some interpret it differently, is we will file a record of survey separate and before we file a subdivision plat. So in that case, we may not file our field notes, but we do have our narrative and some of the stuff we've talked about that gets filed behind the subdivision to talk about how we got to the subdivision boundary. And those, in this case, we're really talking about two different things, right? We've talked really about surveys in general, right? The retracement of a boundary. And now in this case, we're talking really in depth about evidence, right? How are we performing that survey? And so, we talked about in the last couple sessions that our list of evidence we gather, we pull all the adjacent surveys, all the adjacent subdivision plats, we draft them up, we put them in CAD, we send our field crews out with this list of things to try and get. Well, I think in this particular principle, when it talks about adjacent subdivisions, and in the first principle, it talks about this more, in a deed, you can read a deed that says beginning at a point, going, north 444 feet to the Sweetwater subdivision plat. Then it's along the south line of the Sweetwater subdivision plat, 200 feet, right? The second that deed, that document, puts into writing another document what the chapter teaches us is that subdivision plat, even though it's not being recorded as an official document with this deed and a conveying document, because it's referenced in there, it does become part of the deed. But some good questions there. Anything else on principle 1?
Actually, I'd like to add something
please.
to address Rosalie's question. For example, in California, when you're doing a subdivision map, you are showing how you arrive to the boundary on the face of the subdivision map itself. So it's a combination of a record of survey and the subdivision. And then speaking of field notes, this is the part that I really wanted to address, is in many municipalities, especially for the street center lines, you are supposed to provide centerline ties in the form of field notes that will reinforce the location of these monuments and help their preservation and location in the future. And these centerline ties are often submitted in a field note format. So that's about the extent of where the field notes may enter some sort of a record.
The other, thank you, Connie. I think absolutely, and it's great to see how other states do it. The other thing that when I think about using field notes is like original GLO notes or BLM notes, where I'm looking at an aliquot part of a section, and maybe the section corners aren't in or whatever it might be. I've got to go back to those original field notes, which are part of the public record, right? The BLM and GLO notes. And so that becomes part of that written evidence, is looking through those original ones as well. So does that answer your question? Did we kind of hit that? We kind of all talked about different portions of that. Make sure we don't leave you with more questions after that.
No, I got it, but I think that that if you are doing something, doesn't the field notes, maybe what it isn't unambiguous now, it will be in the future. So carrying those field notes as part of the public items that you bring is something that in the long run will aid any future questions that can arise. But that's just me.
No, you've hit it right on the head, right? And there's a couple of principles that talk about that in here, but I mean, the whole point of this, right? If there was no ambiguity in any deeds, we wouldn't be having this discussion, right? We would just go out there and survey. It would be a pretty simple one. So anything we can do, whether through a record of survey or through some sort of keeping of field notes to help understand and interpret deeds, yeah, that's great. And that's going to be state to state to some extent about how that gets addressed. Okay, let's jump over to principle 2 then. All words in any written document should be interpreted as having the meaning at the time of the document was created, and not at the time today's surveyor attempts to retrace a property. So old-timey English words versus now versus what and how we may convey property in the future. Each of those words are going to have different meanings. And in my PowerPoint I put together that I'm not sharing with you, I went through and I wrote down a ton of weird words that I've seen in deeds, and I want to have you guys kind of help me add to this list a little bit and maybe help even interpret what we understand now versus what those words may have been in the past. So one of the ones, the most common ones I see is this is just in the flourish of how people write their deeds. but you have commencing at a point, beginning at a point, beginning at the true point of beginning. There's about 2,000 different ways I've seen people just write in their language how to get to the point of beginning and where that point of beginning is. And that changes over time and region. I think those are less ambiguous because it gets us to the true point of beginning or the point of beginning of a deed. But there are definitely a lot of different ways to write that and possibly interpret that if you're unfamiliar with the regional colloquialisms, if you will. The one that I always wonder, the hardest one to interpret is along, right? To a fence line and along that fence line, or to a hedgerow and along that hedgerow. And so from a survey or a deed standpoint, let's throw this out to the group. Where do you go along that fence, that line, that whatever, that hedgerow, especially where that's got depth or width to it? What does along mean on the face of a deed?
Anyone?
My general default for any words like that have potential ambiguous definitions is to go straight to Black's Law Dictionary. And whatever Black's Law Dictionary is, use that as a starting off point. I'm scrolling through it real quick here, fast as I can to get to along the definition for. When I get to it, I'll read it to you from her book.
Okay, perfect. And then how do you, the other side of that is how do you teach your field guys to locate along a fence line, right? Is it at the base of it? Is it the center of it? Is it and really that gets back to the field notes too, right? Mark it, describe it, tell us what you did, where you shot it, so that when the guy sitting behind the computer with a dot that's, less than a 1/4 inch wide, he knows where that fence line is. It's right where that dot is. Tree calls, right? We've seen calls, particularly in the colonial states, right, where it's more bounds, right? They're calling to trees, they're calling to natural monuments, and understanding and being able to interpret, okay, that's an oak tree, that's a maple tree, the tree's gone, any number of riparian calls we just talked about, and we'll have a class about that. And then to a street, calls to a street, and a lot of that's going to then go back to the public records of field notes or county records, city records for that, state records for that street. But is it the center line of the street? Is it the right of way of the street? And the face of that document may not exactly tell you what you're doing, and so you've got to go outside of that document then to understand what people have done adjacent to you and through there.
And adding on to that, like the right of way of the street to the east line, following the east right of way line, I see a lot of that written in the old easements by let's see, any irrigation stuff out here in California. It's always to the east line of the right of way, so you have to go out there and document what is the right of way now,
Okay.
is it the same as it was back then,
Okay,
Yep.
I got it in blacks here, so let me just go through this real quick. Lengthwise of implying motion or at or near, distinguish from across, by, on, up to, or over, according to the subject matter and context. The term does not necessarily mean touching at all points, nor does it necessarily imply contact.
Mhm.
So we had this discussion a couple weeks ago, I think, in a Mentoring Monday with the property writing, property description, coincident versus along. Coincident meaning, in fact, touching or being with, whereas along is sort of like adjacent.
Mhm.
Adjacent doesn't necessarily imply touching either, but it may be close proximity to. So that's another one of those potentially ambiguous terms.
Yeah, that's great, Jerry. Another thing I'd add too is that we're given a lot of presumptions in law, which really are the simple, boil it down to one thing that will be true in all cases, except when it's not. So it's always the go-to initial go-to reaction when you read a call to a monument. Any call to a monument is presumed to be a call to the middle of the monument,
Right. Yeah.
center of the monument. So a call to a street, center of the street. Call to a hedgerow, center of the row. Call to a fence, center of the fence. Except when, or call to, well, I'll go with that. And then in this list of exceptions, you have, like one comment was to an irrigation, east line of an irrigation, or east line of a right of way on a highway. If those are easements, the presumption of law is you called to a monument, you go to the middle of the monument. When it's an easement, that presumption will prevail over the call to the east line of an easement. It's presumed that you will own to the middle of that monument. And that if you think about the GLO public land survey system, which didn't create new laws, by the way, it just, it's a manual on how to follow the existing boundary laws that still exist. You look at a riparian situation where you've got a navigable stream where the boundary line is the high water mark, and the bed of the stream is owned in fee by the state. You have a separation of ownership. So to go to that high water mark, to the west bank of the river, let's say, stops at that ownership boundary. But if it's a non-navigable stream, the presumption is they own to the middle of that stream. And so a call to the east boundary of the stream is interpreted or construed as a call to the middle of the stream. That's where the ownership line is. But the east line of the stream, or the meander line, is used to determine the area of the upland, because you don't want to pay your $1.25 for the land in the river bottom. And so those situations where you're up against an easement, it is common practice to go to the edge of to call to the edge of the easement for your boundary, your area calculation, your net usable land area, as opposed to the boundary line, the ownership boundary, which is actually in the middle of the easement. And that one gets confused a lot by surveyors. Because my deed says I can only go to the east side of the highway, so I stop there. Well, not if it's an easement. If it's an easement, they own to the middle of the line of the road. Here in Utah, we have a statute, and a number of other states have a statute that dedication of a street by plat, by road dedication plat or by subdivision plat, you dedicate that street to the public. It's a dedication in fee title. The public owns that strip of land, but the adjoining landowners own to the middle of the road. And there's a dual ownership going on. The public has preemption or preemptive rights over that ownership. But if they ever vacate their ownership or terminate their ownership through a vacation process, that half of the street reverts back to the lot owner. And it's always been part of the property, the lot owner's rights. He's always owned to the middle of the road. It's just that temporarily that ownership is now in the public. Public removes their ownership and it reverts back, and you only own to the sideline now. So we have to be careful a lot of times on where we show and how we distinguish the fact that, well, this is an easement, therefore my boundary is here. And yeah, the east line of the road, it's still here, and I'm using that for my net area calculations.
Wonderful discussion. Thank you, guys. I mean,
exactly.
I just want to sit here and talk about this because I know it's not the point of this discussion. I've got questions, John. I know scenarios where I'm like, well, what if? Well, we could go 15,000 what ifs, right? But that's not the point tonight. But no, that is great. I mean, that so clearly denotes exactly what this principle is, right? Words have meaning. Words have meaning now versus then, and they will in the future. And these meanings may change, they may not, or they have specific meanings, and we need to understand that. Going to the east line on an easement versus the center line versus the, or calling out to natural monuments like a river, right? To the bank of the river, to the center of the river, to the high water mark, whatever it might be. Each of those have very specific meanings and use. And I think Jerry said it best. One of our first resources should be Black's Law Dictionary, right? That's where we jump off with. I know when I was preparing to take my test, there's a BLM book of vocabulary words floating out there, right? That's another really great resource for some of these words. Excuse me.
UCSM one as well.
Yeah, the ACSM standard terms and glossary or whatever. Yeah. One of the other points to Nick has his hand up, but I'll get to you in a second, Nick. But one of the other things to kind of point out too, right, along the same conversation is a new case law could come into effect tomorrow, which will change. Yeah, there you go, Jerry. New case law comes in, and a new meaning is pretty much put into place tomorrow based on decisions and court decisions. So go for it, Nick.
Yeah, I was still thinking about that along thing. But I wanted to add one point, at least how I think about it, because I've thought about this one quite a bit. And what I like to do is just try to imagine what's practical. And whoever came up with this description that said, go along this, they were attempting to be clever instead of saying, go this bearing, distance, whatever. So it's a physical thing. It's in the case of a hedgerow, you could put a boundary line right down the middle of a hedgerow, but my guess is that when they wrote that, they were intending to include that hedgerow on one side of the line or the other. And so the practical part of it, in terms of stability for me is where I want to go and find that intent right away.
And that will roll right into our middle principles, right? The parole evidence. If there's ambiguity with along, well, let's look at the parole evidence. We start looking at the parole evidence in the testimonies, and we know that landowner B planted that hedgerow for a wind privacy, right? And air protection, wind protection, or a site privacy. Well, all of a sudden along becomes very different once you add in the additional evidence.
Yep, good point.
Okay, let's jump over to the next principle here. Principle 3, descriptions do not identify themselves, and all that is required of a deed is that it furnishes evidence or a key of a means of identification. If the description in a deed is sufficient when the deed is made, no subsequent change in conditions or loss of evidence can render it insufficient. That's a hard one to kind of put my mind. I read that one half a dozen times to try and understand. And I'm just going to put it in stupid Trent terms here real fast. The way I understand what this is trying to teach us, if it worked then, it works now. We may have to do more work to get to the meaning, but if it was proper enough to convey property when it was originally recorded, then it should be sufficient now to identify the deed on the ground. And that's where, us as professional surveyors come in to interpret that and understand that. Anyone disagree? Want to fight me on that simple interpretation there?
Actually, I have a quagmire that I'm dealing with right now that probably falls under this principle. where I have a 5-foot overlap between two property owners, and one side wants to establish a section based on where they think the section line sits, and ignoring about 120 years of other landowners and subdivisions perpetuating a certain location to that section line. So there's no solution to it yet. It's going back to a little more research, but basically two different surveyors are looking at they're cherry picking two different sets of evidence to try and substantiate where they're putting this boundary and creating a potential 5-foot overlap.
The joys.
and the description is very, very clear. It's simple. It's a southeast quarter section, but you know, of course, the debate is where that section line really sits.
Gotcha. Yeah, that's the tricky part right there.
Yeah, and who is right?
And that gets into the, you know, gathering of evidence, and this is where I appreciate that. I mean, that is our job, right? It even says, you know, in a couple paragraphs into this principle 3, one of the most difficult tasks of a land surveyor is that of having to take the written words in the description and place them on the ground with a degree of certainty that says, here is your parcel, no ifs, ands, or buts. Right. I like that. And it's true. That is the hardest part. So this is, I'm going to turn my camera on, see if I can't flip this around. And this is one that I've been dealing with. Let's see if so I can see what I'm showing you guys. Instead of my ugly mug. Oh, there we go. It is faced the right way. This is a quit claim deed from, let's see if I can find the 1969. Okay, so when you look at the face of this deed, this is one it's caused a lot of headache because it's interpreted two different ways, and I know it's probably hard to see on the computer screen here, but a quit claim deed would assume transfer of title, right? It's described here, and the way it reads is a tract of land 60 feet in width, and this is the part I'm going to ignore this little highlighted red part here. So tract of land 60 feet in width, being 30 feet wide on each side of the following described center line, measured perpendicularly there too. Again, these words have meaning: along, perpendicularly to, coincident with. But it says beginning at a point on the south line of North Plain City Road. So part of my procedures as surveyor is I've got to figure out where North Plain City Road was at the time this deed was written. South 8843 east, 442 feet, south 4 degrees 18 minutes east, 1024.56, and north 86 degrees 53 minutes west, 20 feet from the northwest corner, the northeast quarter of section 27, 7 north, 2 west, Salt Lake Basin Meridian. And running thence south 1 degree 25 minutes east, 837 feet to the south line of the grantor's property. Now in here, there's nothing that's all that difficult to necessarily retrace, because I can go back in time and pull the grantor's original deed, and I can find the undocumented but historic right of way of North Plain City Road. The interesting thing here is right here, to be used for right of way purposes. And so words have meaning. Right of way purposes would assume some sort of road. Now this is very rural Utah, and so kind of the assumption, I argued this just for sake of argument, that the people that owned this, there were farmers. So right of way purposes to come across and over the land with their farm equipment, because this was really the easiest and only access off of North Plain City Road, right? But then again, it's a quit claim deed. So there's ambiguity in this. And this is one that I've really enjoyed, kind of just going the rounds with some people. Ultimately, in this case, after much arguing, almost a year and a half arguing, the the owner of the land they are giving this one up, and they're actually buying fee title a right of way and kind of ignoring this one. But to make things more difficult is the county, in putting this into their county records, didn't actually transfer title with the quitclaim deed. It stayed in the grantor's property from 1969 till now. And so, whoever they were going over for this right of way, they were okay with it till they weren't okay with it. But they've got this, the argument was they never actually owned it in the first place. And then change actually happened, right? They want to put a subdivision in, and so was the intent at the time to do a farm right away or road right away or own and fee title. And so you've got to go outside of the evidence in this and what those words are. And in this case, the parties that affected this deed are no longer around. You can't get parole evidence, so it's been a fun one.
You've got a patent ambiguity right off the bat in there because your beginning point is not defined. All it does is it gives it somewhere on the line, but it doesn't give you any distinct location on that line for your beginning point. So you have an ambiguity right off the bat with respect to it.
Yeah, but that was the easiest one to uncover, right? Of all those on there, at least from a survey standpoint. Once you start drafting up and looking at, the parole evidence, that was the easiest one. But I like that when you look at words as evidence, even the title of the document, a quitclaim deed, right there, you would assume it's a transfer of title, and then it says for right-of-way purchases, and the parties did not transfer title, nor did the county. Right. So what do those words mean today?
Yeah, Trent, I read that document a lot more clearly than and would say that, yeah, there's some ambiguity as far as location and such that you've sorted out. But from the meaning of the document, the title of the document is irrespective of the particular description. What is in the particular description in the document takes control over and overcomes the title itself. The title has meaning and it may help to interpret the document, but that's only if there is this ambiguity caused. And the fact that it's a quitclaim deed technically means if we have an interest, whatever interest we're conveying, we convey it. And so it's very loose and can convey any kind of an interest that they may have or desire to convey. Whereas the particular language in the document is, and you've brought it up several times, is not really the for use as a right of way, for right of way. The document, the word that really is key there is use. When you're granting property for use, that implies an easement or infers that there's an easement interest that's being conveyed. Otherwise, the only other possible interpretation of the word use is that it's a reversionary fee title. You can use it for a right of way. You stop using it for a right of way, and the title will revert back to us. And those are the only two real possible interpretations. Either way, it's limited on its use. And as the key word and the only key word in the actual conveyance document, that it's got to be conveying an easement interest, in my opinion. But even if you took the interpretation, and that appears to be what the county recorder has done as well, says, well, it's a conveyance of a use. Use is easement, so that's not a fee title conveyance, and they leave it in the fee title in the original grantor, which to me is kind of, that's jumping back to last week, corroborative evidence. It's not evidence that means something. How did the county interpret this? That's not going to be definitive or any kind of evidence that's going to stand off on its own. But yet, the interpretation we come up with, then I would start looking at what kind of evidence corroborates that, and others' interpretations corroborate it. And if all it was to travel to and from their property, all they really needed was the right to use the strip of land. So they only needed an easement. Granting an easement fulfilled the purpose of what they needed, and it's a grant of use. So I would say all of those things default me into an easement category rather than fee title.
And I agree with that. That's kind of my at the end of the day, I argued all the terms, with the developer, with the title, because I was trying to get an understanding of it. But that was my understanding too. I took it a step further, just to protect my client, and again, this was purely argumentative, but the intent of that use, right? Was it just an intent for a right of way for the farm equipment, or they want to build a subdivision? They're not changing the use per se because they're still using it as an access point. But instead of a tractor a week, now they're going 30 cars a day, right? Does that use change and the intent change? An interesting discussion, but point being, and the reason why I want to share that particularly in this is there's a lot of words in there that have meaning that counteract each other. And what was the meaning or intent in 1969? And how do we interpret that now versus the meaning and intent, and how do we interpret that today? Well, we have to go back to 1969 and their original intent. Okay, any other words that you guys have encountered, or do we want to jump on to the next principle here?
There's a lot of hot discussions surrounding the meaning of right of way and what was the intent, what kind of conveyance was the intent of right of way. And you will, for example, here in California, you will have different county surveyors where some will say that the intent was to convey full fee title, and of course the abutting owners would have their reversionary rights. And then there's other counties that will swear that the intent was to only convey an easement. And I haven't dug far enough into it to see if there's any kind of a legal precedent regarding that one. But
I was going to say, even with California, right, the acceptance, whether it's accepted or not by the county too, that's a whole nother.
Yeah, well, this is assuming the acceptance, because you have like in the recent, I would say, decades, now they spell out the intent, whether they grant it as a fee or they grant an easement. But there's piles of documents from probably 1900s up to 1970s where the actual nature of title transferred, or which rights out of the bundle have been transferred and which have not, and it's creating a lot of heated discussions.
Yeah, I could say that the presumption again is that it's a right of way is a right of way, a property right. So it's not title. It's a property right, and as a right of way, it's a right to travel back and forth, or to a right of access. And it's more of a general sense terminology rather than, say, access easement or ingress egress easement, where you're getting more specific on the use. Where right of way, you grant a right of way, it's a right for those properties, and it attaches itself to as an appurtenant right to that property as a necessary function to get to and from that property. And it's a general purposes right of way. By general purposes, they term it as it's not only for its current use or the use at the time of the conveyance, but it's also includes any future renditions or mutations of that use, permutations of that use. So, it might have been a right of way for farm equipment because it was a field. Well, now it's somebody built a home in there, and so it's a right of way to get access to the same piece of property for the same thing to use the property. And so it's a more generic and more inclusive type of way rather than specific purpose described easements.
I think this discussion really goes. I want to read real quick principle number 4, because I think we're starting to roll into this and kind of cover this fairly well. But principle 4 says, when the terms of an instrument, deed, or will have been reduced to writing, they are to be considered as containing all those terms, and there can be between the parties or the representatives or successors in interest no evidence of the terms of the instrument other than the contents of the writing, with several exceptions. I think that the challenge we have is we want to add meaning to these words sometimes. Just like the deed I was showing, did we want to add meaning? That what does that right of way mean? Or was it a quick claim? But saving just these first 5 exceptions here, that deed should be considered complete unless there are egregious errors in the deed. And so the interpretation of right of way, at least as far as surveyors are concerned, is it's a right of way. It's a way of passage. And we've got to be careful to go outside of that, because that gets into legal interpretations of the deed versus locational interpretations of what the deed is trying to tell us and what we are locating on the ground. Go through these exceptions real quick. Where a mistake of imperfection of the writing is put in issue by the pleadings, where the validity of the agreement, deed, or will is the fact in dispute, to establish illegality or fraud, to explain an intrinsic ambiguity, or to show the circumstances under which the instrument was made for the purpose of properly construing the instrument. And then they go on to say that in the foregoing, the surveyor usually is not concerned with items 1 through 3. These are matters for title companies, abstractors, attorneys, and ultimately the courts. Right? Again, the very first chapter, the first few parts of this book, and I kind of argued against the way they started out the book, but when I read this chapter, I kind of get in line with what they're trying to say, and that they're trying to say, hey, surveyors, stop worrying about what some of this stuff says. Your job is only to take the document and put it on the ground and perhaps review a bunch of evidence that goes around it to properly put it on the ground. Thoughts, questions, arguments? Prove me wrong. I'm game for it here.
Here in California, they've taken it to the Code of Civil Procedure and have actually written it down in our California code that when you're interpreting a deed that is perfect, you cannot frustrate the conveyance by bringing outside information into it. So even though the intent may be obvious when you're laying it down on the ground, if the deed is perfect the way it's written, that's the way it needs to stay. And sometimes that's really difficult to do when you can clearly see what they were trying to do.
Yeah, again, one of the most difficult things surveyors have to do is, let's read that paragraph again. One of the most difficult tasks of a land survey is that of having to take the written words in a description and place them on the ground with a degree of certainty that says, here is your parcel, no ifs, ands, or buts, right? And maybe we want to because we see it, experience, right? I mean, we've all been asked, I've been asked many a time to put together a deed. And I say, look, I stare at these all day. I could probably do it for you, but that is not my area of expertise, right? That is not my job. My job is to tell you where that deed falls in the ground, but it's really easy because we deal with that. We read them and interpret those every day, and to come back into our professional obligation.
I got something to say on the deed, and that is, when somebody writes that, they're intending to describe a parcel of land, and we don't need to take that as verbatim for where the boundary is. That's really just the title, and we hope that we put good evidence into that deed to help us later find the boundary. But when we're talking about laying these lines on the ground for the first time, it's, that's one thing. We're attempting to take what the landowner intends and put that on the ground and we mark it. But everything else is a retracement. And in this case where we're talking about title, well, everybody's owning to their boundaries, and the question of where is the boundary on the ground, there's other things that we need to take into account other than a bearing and distance.
The problem that we have, or a problem that we have, is there are rules that we have to follow when we interpret evidence and descriptions. Unfortunately, there aren't rules that the people that writing the descriptions have to follow to make it easy for us. So they can write it pretty much any way they want to, and then we have to try to figure out what it is what they said. But the courts have ruled over and over again that you have to interpret within the four corners of the deed. You're limited by a description. You cannot you can't enter into the minds of the parties to the conveyance to try to say, well, what they really meant was. So you're limited to those words. And that's why sometimes when you're doing the rules of construction, you're trying to apply those to weigh the evidence based on the writings of the deed. Some of the stuff in there doesn't make any sense because whoever wrote it didn't really understand the implications of the wordology that they're using. And they say the southern 200 feet of a parcel, presuming that it's got 400 feet, when in reality it doesn't. So that's the stuff we have to wrestle with today.
I would take it add one step of caution there, though. The four corners rule does not apply to boundary principles. Four corners rule applies to the transfer of the title and the sufficiency of the deed and the document itself. So the rules of construction on the document and all that stuff, which is what we're talking about here, the four corners does apply. But I would defy any surveyor to pick up any deed and survey it without considering any extrinsic evidence. It's impossible. As a surveyor, we have to include the extrinsic evidence.
My point is you can't use that extrinsic evidence to change what the intent was in the deed. You can use it to try to clarify that, but you can't just wholesale change it and say, well, what they meant was this, not this.
Right. You can't use it to change the intent of what they're saying. But take a north, south, east, west rectangle that closes perfectly, has absolutely zero patent ambiguity. And you go to put that on the ground, it isn't going to be a rectangle that's all 90 degrees in the perfect world. It's going to be rotated. It's going to be following lines based on prior surveys, monumentation you find on the ground, actions of the parties that have established their boundaries in certain locations based upon whatever evidence they had at the time they did it. So all of that extrinsic evidence is included in the when you lay it out on the ground. What we're talking about here in this principle is a patent ambiguity, one that's present on the face of the deed within those four corners. And what you're saying is true. But when we go to lay it on the ground as surveyors, now that with those latent ambiguities come to light, and that's where we must now use our survey principles to determine what latent ambiguity, what latent extrinsic evidence there is that will explain those latent ambiguities. Why isn't it a rectangle? Why isn't it a perfect, perfect 90 degrees? Why isn't why aren't the dimensions to the nearest 3 decimal places? And those are survey principles it's an entirely different set of laws. Really, you've got your patent ambiguity laws, and then you've got latent ambiguity instructions of the surveyor that we follow laying it on the ground.
Well, and let's use the book here to kind of frame the discussion we're having with the differences. Trent, on your screen, can you scroll up just a hair? So we're on 3.5, rules for the interpretation of writings, right? So right here in the book, it gives us the rules of how we should be doing this, right? And I'll just take a second to kind of read through this. I think this will help give framework to exactly what John and Jerry are talking about. How do we take that deed and interpret the writing thereof? Often in a surveyor's professional life, the interpretation of the meaning of various words and phrases contained in written evidence will be required. The following 7 rules may help explain the significance of evidence and are generally applicable in most states. The language of a writing is to be interpreted according to the meaning it bears in the place and at the time of its execution, unless the parties have reference to a different place or time. In the construction of an instrument, in the place of the judge is the judge is simply to ascertain and declare what is in terms or in substance contained therein, and not to insert what has been admitted or to omit what has been inserted, where possible to be adopted as will give effect to all. In the construction of the instrument, the intentions of the parties as expressed by the writings are to be pursued, if possible. When a general and particular provision is inconsistent, the latter is paramount to the former. So in a particular intent will control a general one that it is inconsistent with it. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject of the instrument and of the parties to it, may also be shown, so that the judge is placed in the position of those whose language he or she is to interpret. 5, the words used in writings are presumed to have been used in their primary and general acceptance, but evidence is nevertheless admissible that they have a local, technical, or otherwise peculiar signification and were so used and understood in the particular instance, in which the agreement must be construed accordingly. 6, when the characters in which an instrument is written are difficult to be deciphered, or the language of the instrument is not understood by the court, the evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the characters of the meaning of the language. And 7, words expressed in a deed or conveyance reflect the intent and the meaning of the words of the parties at the time of preparation, not necessarily the present meaning. Most frequently, the need for explanations of words arise from local customs, such as the local name for trees, water bodies, and unique elements that may be specified to a local area. What does the term spotted tree mean in Maine? Is it a blazed, hacked, or marked tree? What is meant by plug, a 2x2-inch wooden stake? Is it a branch? Is the same as a run, creek, or bayou? What is a bar that was called for in a deed? And all these terms have local meanings which the boundary surveyor must know. So to simplify this a little bit, I mean, the thing that pops into my mind on the face of the deed, right? The 4 corners of the deed, we're going north 500 feet to a fence line that's along the fence line, and you out there and measure it, and we're actually 495 feet measured to that fence line, right? The 4 corners of the document, it's clear the fence ends up holding because it's called to in there despite the actual measurements, right? And so these are the rules that we can say, okay, I can throw this one out versus the other one out. Does that help clarify things and kind of spur on that discussion a little bit without getting too deep into the woods?
For sure. And I think Connie put a good one in the chat too. We have interpretation of writing and we have interpretation of field evidence. While they can happen simultaneously, they're 2 totally different processes, right? And so that's a good thing in the chat there, Connie. You got we're down. I know you're at waiting for a wedding reception as well, so we're down to about. We try to keep these at 90 minutes, so we're at 14 minutes left, and I think we can probably run through this last principle 5.
Yeah, I think so. My family was at keep it quiet for just a second. I wrap up this. I just lost my place in my book here.
I was gonna say we lost part of your connection there too. So you say your family was checking on you. See how much longer?
They were at a movie, and so they just got out of the movie. I was hoping to time it just right here.
Oh, okay, cool. Yep. All right. Well, we're almost there.
There's nothing suspicious about sitting out there in the parking lot in the car during wedding.
That's right.
Yeah, exactly.
So
Gary Kent did it for us last time, so you're in a good company doing that.
Yeah, Gary did a leadership one, and then actually, believe it or not,
that's why I figured I could get away with it.
Yeah, and Gary Kent actually did a roundtable Tuesday from his car as well one time, from the ball field. So it's awesome. It works. Modern technology, you gotta love it. It's only going to get better too.
It does. Well, so principle 5 here, it says each deed should be construed as a whole. All parts are read in the light of other parts. Nothing stands alone and nothing is rejected unless it is impossible to give that part a meaning. And so I might take this and why I agree with what John said about the deed that I presented, but in some sense, what he's saying there, and again, that's the intent of the deed, not the location of the actual boundary, right? When we talk about this, but by rejecting the quitclaim portion, and not so much, because that's any claim or right they might have to it, but by rejecting that and saying use holds to a right of way, you're almost rejecting a portion of that document for another one. And I don't know if that necessarily applies to what's being here, but that's something that comes to my head as I ramble. It kind of popped in there. So I'm saying it as it's coming through. But when you look at a deed, you can't reject one portion of it and accept the rest of it. The intent of the grantor plus the intent of the grantee equals the true intent of that deed, that document. And maybe John, you can argue against me there. I think maybe I'm going down the wrong road when I say that, but I'm just curious there.
He's shaking his head. No, he's not going to argue with you. He's in agreement.
Argue with that.
Yeah.
No, as long as we're clear on what we're doing here is interpreting the words of the conveyance, and then it's a matter of which words take priority over other words when there's a conflict. And which was all I was trying to point out in my conversation there was, the title on the deed takes less, is subordinate to the specific language in the conveyance document, which conveyed a use. And so it's just a matter of priorities. And that's why we're given the rules of construction, is to be able to categorize and put these words in sequence, in their proper sequence of what controls over the other. And that's what these rules of construction do. And that's the reason we have them, is to make sense out of those 4 corners and all the words that are contained in the deed. I had an interesting case where I kind of got into somewhat of an argument with a judge, that we had a deed that we had a series of deeds, all had the exact same language conveying a right of way or an access road to this property. And it says an existing right of way along this northern portion of the south part or something like that, some generic language. But the judge looked at it and says, wow, that doesn't make any sense. And so he threw it out. He tended to just throw the whole thing out. And it was the right of way spelled out a width, it was 24 feet wide, gave us this generalized description. Well, the property was one parcel, had a road that went right through the middle of it. They sold property north of that road, a few hundred feet north of the road, they sold a piece. And that piece they sold had the exact same language as the rest of the property that was broken out later. And the judge tended to want to just throw the entire thing out. And I said, no, you have to construe this language to make sense out of it. It has to have meaning. And the only meaning I could put to it was, well, there's an existing road that goes to these parcels and has been used ever since, was used before the parcels existed and has been used ever since they've existed. And he just refused to hear it. No, it doesn't make any sense. I don't care what you say, doesn't make any sense. You just have to ignore it. And it's like, okay, and then we had to provide evidence to prove how wide this easement was, because we now have evidence of a prescriptive easement that took 20 years of trespass to acquire, and had to present evidence as to how wide this prescriptive easement should be, which ended up being, I think he ruled it was 22 feet wide or something like that. And it's like, man, you throw out all the language and then you have to argue what creates this easement that you just threw out that was clearly expressed in every one of these deeds. It meant something when they wrote it. You just can't ignore it.
That's awesome.
Okay, yeah, thanks, John. Thanks for clarifying that too, and that a great example. You know, I think that also just speaks to sometimes judges are just that, they're judges, right? They don't deal necessarily in land all the time, and so there becomes a point where as expert witnesses, you know, or subject matter experts, we can add some color to what they're trying to understand and portray. Jumping over, I just want to cover principle 6 real fast, because I think we've talked about this and covered this one pretty well. But it says writings or plats referred to in a conveyance for the purpose of identifying land are to be regarded as a part of the conveyance itself, as much as if incorporated into it. You know, proper writing of a deed it's not just north, south, east, and west, right? It's north along a natural boundary call, then it's west along, you know, a monumented line, a subdivision line, then it's, you know, around a, you know, whatever it might be. But the more that we can add into a deed in that way, the less ambiguous it can be, right? You can clear up any missed measurements or bad noted numbers or be what it is. But the second we add in these calls and in this principle, you know, a subdivision plat or even an adjacent conveyance, right? Thence along that property conveyed in entry number and book and page, right? All of a sudden you're saying that these two lines are coincident. They are the same line because this is the deed that holds this line and we were holding to it and we agree that this is the same line and we're going along it. I think that's what this principle is calling for. When we interpret it, we add something in there, even though it's not filed and recorded with it, that becomes chain of evidence and chain of title, and you hold to that as well, and forces you to pull up those deeds and look at them. That was pretty clear there.
Yep.
I think that's probably a good spot to end. We've got about 7 minutes left that we want to try and hit, but are there any other questions or discussions about these first 6 principles that we've talked about that we want to address, clear up anything that popped up that you're like, that just doesn't make sense? Let's just take the last few minutes here to answer any lingering questions, and then maybe just do some prep for the next half of the chapter in 2 weeks. Anyone have their hand raised? Throw anything into the chat there real fast, and let's see if we can address it real quick.
Nothing yet, but I would do, just because we've brought it up quite a bit, talking about rules of construction. Jerry had done a presentation that's on Mentoring Mondays under week 46. You can go back and watch some of that to kind of get a, premise for rules of construction. There's also a Dropbox link inside that Mentoring Mondays site to Jerry's presentation. He had given us a homework assignment leading into that. So there's a lot of stuff that can kind of roll back into the rules of construction on here. So just want to throw that out there for anybody watching who may not have saw that presentation earlier as well. But John, you had your hand up. Did you Yes, no?
I was just going to add there that you on this last principle, this principle 6, that when you're writing a composite description or for whatever reason writing a description of a parcel, the title companies love it when you call to and along the adjoining property by referencing their recorded document, because it limits their insurance to wherever the boundary is. That's where they're insuring to. And if somebody comes in later and proves the boundary to be in a different location, that's where their insurance went to, is because you've got a call to that adjoining property. And so it's a real easy way to satisfy the title companies by including those calls to adjoiners, even if they're junior.
Yeah. That's awesome. I love it. Brian, I know you just jumped on there late, but I'll get this first part of this whole video up later this week so that you can kind of go back and jump on it. But
I do apologize. I've been wanting to be a part of this for quite a bit of time.
Yeah, no
and
worries.
have not made it,
yeah,
obviously.
we're all busy. Yeah, no, we're all busy.
We'll make you present next time then. The
You're late. You're up next.
so I'll background this a little bit on my part. Yeah. I've been like I've been pigeonholed somewhat into a construction background for a long time. I'm licensed in multiple states, but I really want to learn a lot more and get a better understanding of what I should be trying to do.
Yeah.
In boundary survey, because boundary survey is where surveying really is.
Absolutely.
Constructions. Yeah, we don't even want to talk
You're
about
preaching to the choir. Yeah. You're preaching to the choir. We all get it.
I think you're in the right spot. Can I just say this? I left last time a little defeated. Trent and I were texting afterwards, and I felt that it definitely fell a little flat. This one has been a breath of fresh air. This is what, I gave my plea at the beginning, and I'll give it at the end here. This is what this should be about. We've gone down some rabbit holes, but I feel like I'm a better surveyor now than I was an hour and a half ago. And I appreciate you guys that have jumped in and asked questions. I'm going to throw out a homework here now for everybody in preparation for the next one. And I'm just going to say, bring your ambiguous deed. Let's see if we can't throw a couple on the screen and we're not going to spend time interpreting them and reading through them, but let's just everyone find one that was just a head scratcher here. And let's see if we can't, without spending too much time, kind of like we did on mine, apply some of these principles to it. That's the homework I'm going to throw out there for 2 weeks. Besides reading the rest of the chapter again,
love it.
Bring your show and tell deed next time.
That's cool. I'm good with it. Awesome. Well, I know you got to get busy, and so I appreciate everybody's time. And of course, we love John and Jerry and your guys' input every week, and we totally enjoy it. So I love bringing different perspectives like I talked about in the beginning. So I hope everybody has a good rest of the week, and it's not back until July 13th. That's the second Tuesday. So it's July 13th. So we got a good time to get that homework assignment and get, we still got 13 more principles to go just to get through chapter 3. So I love it. It's awesome. And then Brian, I'll do a follow-up email, and you'll catch that follow-up email, and you can kind of go back and watch some of these. So they're all
appreciate it.
They're all on wisdomwednesdays.xyz already. So everybody's
good deal.
Awesome.
Trent, I had one question I put in the chat. Please. Is anybody using this time for their PDHs for their hours? Is anybody clocking it for the PDH hours for continuing education?
Oh, I missed that. Sorry, fell in the middle. I will tell you, I guess it probably depends on your state, right? But for Nevada, we changed the law administrative code a couple of years ago that allows for self-study. So you're able to, if you need Nevada PDHs, you're allowed to use these as a self-study PDH. But it probably depends on some state how their state law is, right? But I know for Nevada, you are good for self-study, and these would be totally fine for that. So
Jerry, do you know if Wisconsin is doing that? I'm licensed in Minnesota and Wisconsin. Do you know?
Yeah, there is a certain amount of study time on your own type of stuff that you can use. I don't recall off the top of my head how many hours it is, but yeah, you can book some of it towards that.
Great, thank you.
yeah,
The challenge with Wisconsin is you got to get the state specific stuff, and I'm licensed in Wisconsin, but can't get the travel out there. So I'm trying to figure out how to get the rest of my PDHs out there.
That's why the Supreme Court decision I put in chat was the Wisconsin one. So now you have a Wisconsin connection there. So
There you go. We could use this hour and a half for that.
Yeah. I was going to say, so Nevada, we can use, we have 30 every renewal, 2 hours on ethics, and then an hour on NAC, NRS updates. And so we're good for 27 hours outside of that, but same with thing where we need that hour of NAC, NRS updates. So, but the Wisconsin one that Jerry did throw in there, yeah, it's good stuff. There's a couple more messages. Let me zoom down there. I think we got it.
Very nice job, Trent. And thanks, guys. That was super interesting. I appreciate it.
Yeah, of course. Love it, Nick. All right, everybody. Have a good night. Have a good wedding there, Trent Williams.
Appreciate it. We'll see you guys.
All right.
Thank
Have a good
you.
night. Thanks, everybody.